Scroll across the bottom. Closed captions on,
I don't know.
if you
Um,
could, please.
All right,
we have somebody in the waiting room.
you do.
Oh, Pat, yeah.
If you could give me a minute, Chip has requested that I turn on closed captioning,
Yep.
and I'm not quite sure.
How to do
I don't
that?
have that ready in advance. So let's admit Pat. And I want to get her in on the minutes. Pat, are you present?
Yeah, I'm here. Thank you.
Okay, I'm talking just to see, nope, not those captions. Let's see. Oh. Closed captioning on. So I was worried about this. Closed captioning is designed to show up on a window if you're a participant. So it's on my computer. But I can't get it to show up here. Do you want to sit?
I will, that's your problem, but
Yeah,
Okay. We all set there?
I think so.
Okay. I will call this meeting to order at 7:02 PM. North Arrow Select Board in regards to the development regulations. To a public hearing. Are there any adjustments to the agenda? Hearing none. Development regulation amendments presentation. Notice. Development regulation amendment select board hearing. And we have the bylaw report for the select board hearing and the proposed amendments for the select board hearing. Andy, would you like to?
I'll start off. I think everybody here is familiar with what we tried to do. The select board have been through it. I think Chip and Jeff, you both were at the planning commission hearing. So unless any of you want me to go through anything in detail, we'll just let you have the floor when it's your turn. I guess what I would like to point out two changes that the select board made after they received the document from the planning commission. The first one I think is very important as far as the shoreline setback from Lake Champlain. They added 75 feet minimum setback to the language referencing the State Shoreline Protection Act. I think that was a big one. I was very happy with it. I think it was a good solution. The other change they made had to do with temporary signs, political signs, and basically they reduced the maximum size from 32 square feet back to the 15 square feet that it was before. So those are the two changes since the planning commission hearing. So on that, I'll open it up to anybody that has comments.
Well, with that being said, any public comment here?
I do, please.
Mr. Porter?
For the minutes?
One for the clerk.
Thank you.
And the chair.
Cool. And an extra.
You get it back to me? Oh, okay.
Hmm.
I need it back.
Oh,
Well, there's an extra one right here.
I'll just keep this one.
thank you.
My testimony will specifically address the legal requirements of Vermont statutes relating to the adoption of the changes to the bylaws. It will identify the legal framework required for the select board to approve the adoption bylaws. I will propose specific language to comply with statute via 24 VSA 441. The most important purpose of my testimony is to focus this adoption process on not who is right, but what is right. And to do that, I will reference every statement that I make to specific documents which I will submit to the board for reference in complying with statute. I will provide the board clerk and the select board members with exhibits referencing the issue for your later use. My testimony is that someone did something, it was wrong, we can fix it. In 2024, the PUDs were inadvertently deleted from the bylaws. Planned residential development provisions in 24 VSA were discontinued and incorporated into planned unit developments. The planned unit developments in our zoning bylaw language should have been incorporated, should have incorporated the PRDs into the bylaws, but they will not. In my testimony, I'm not going to try to cast any blame, but I would like to just point out that this error in 2024 is partly my responsibility, and I'm trying to correct that tonight. In 2023, the 75-foot setback from the lake was removed based on false information. And I realize that the select board intends to put that provision back in, but I'd like them to put it back in and comply with statute. To remove a bylaw, a finding is required by 24 VSA 441. And the finding requires that removing a bylaw conforms with or furthers the goal and policies consistent with the town. There was no finding. There could be no such finding because the town plan explicitly calls for these two provisions. This is a problem that I and others have raised. Removing these two provisions means that the town of North Huron's town plan is deficient. It does not comply with statute. The bylaws are required to be consistent and to conform with the town plan. This non-compliance with statute would jeopardize our town's statutory authority to regulate land use development and zoning. Fortunately, it's a relatively simple fix, or to make this process whole. The select board needs to comply with the law, bringing the bylaws into conformance with the town plan as is required by statute. The select board can correct the deficiency to comply with 24 VSA 441 and then approve the changes under 24 VSA 442. Now, I'm going to highlight the rest of my comments that I've summarized fairly specific legal terms, just to make sure that the board and the, people watching are aware of some of the issues. There's a doctrine in Vermont called the consistency doctrine. Vermont laws authorize town plans. And town plans are required to authorize bylaws.
I'm sorry, Chip, we have someone else that wants to come in. No. Hi, Delcy, are you here? Can you confirm that you're here for the minutes, please, Delcy? I think you may be muted. Or maybe she walked
Yes,
away.
I am here. This is
Thank
Delcy
you.
Durham.
I'm sorry if you had to wait a bit. Okay, Chip.
Statute requires that, statute, plan, and bylaws must be consistent. Bylaws cannot invalidate the town plan. And this is called the consistency doctrine, and it'll be, if you want to further reference it, it'll be exhibit 1 in your mailbox tonight. 24 BSA provides town with authority to plan and zone. Zoning is sort of like a company car. The company gets to tell you when you can use it, how you can use it, and where you can use it. And they can rescind it or add to it anytime. But we can only do what we're authorized to do. And that's summarized in the statutes of 24. In this case, 441. 441 requires that a report shall include findings, and that those findings shall show conformance with the town plan. So I will have an exhibit of what's in 441 if you want to look at it later. And 441 allows the planning commission to develop a report, but the report did not include these findings with the 2 issues that I'm trying to raise tonight. And 442, the statute authorizing you to bylaw amendments does allow you to fix this. So what I'm asking you tonight is to make the process whole and to entertain testimony that will allow you to make a finding that says that the 2 proposed changes, the 75-foot and the PUDs complies with the town plan, and by reinstating them will bring the town zoning into compliance with statute. To that extent, I'm giving you exhibit 5, which is the town plan excerpts. You can look at the whole one if you would like. Exhibit 6 is shoreline protection, which I'll address again very briefly. And exhibit 7 is lake setbacks, once again, very briefly. Now, a finding under the terms of statute 24 BSA is a determination of factual evidence and questions and interpretations of how the law applies to the facts and allows you to make a conclusion. You need to have those elements in order to have a finding. Facts, and conclusions. So it might be nice to do something, but if you can't relate the issue to the town plan and show and conclude that the town plan calls for these things and the bylaws need to conform in those things, then when that's done, you can proceed with 4442 and approve the bylaws. So the town plan, for those of you who aren't real familiar with it, states several things. It says explicitly to incorporate open lands, preserve existing development patterns, a very important element in both of the, those are very important in terms of 75 feet setback, further town goals and objectives, create opportunities for affordable housing, and comply with non-discriminatory land development. Now I'm going to just briefly highlight a couple of things that are direct quotes from the town plan to give you a sense of what this means in terms of how our zoning bylaws need to conform to the town plan and not the other way around. And as you remember, perhaps from 2 years ago, an enormous amount of energy went into making our town plan and bylaws conform to state statute. So here's 10. Ensure that when growth occurs, it occurs on our terms. Protect the quality of the environment in the lake. Maintain the visual character and aesthetic setting of North Hero. Use the planned unit development, specifically cited here, to incentivize affordable housing and allow for concentrated development in conjunction with preserved open space. Encourage planned unit developments to use the town permit to process appropriate lands set aside for open space. Protect and preserve the quality of air, water, and impact on the lake. Protect the scenic character of the town. Manage development at low density along Lake Champlain shoreline. Unregulated growth and development could adversely affect town efforts to protect critical natural resources and the environment and scenic view and maintain the value of the view or vista. The purpose of the shoreline district is to preserve water quality, regulate visual character and aesthetic settings of shorelines. The planning commission should encourage the development that preserves open land. Every last one of those words comes directly from our town plan. And the town plan allows the town to promulgate regulations, bylaws to support the town plan. It cannot work against it. So we've more or less given 75-foot setback a full treatment here. But one of the things that I want to put to rest here is the issue of the shoreline protection. There is no shoreline protection for setbacks. Not in the text of any shoreline protection documents. I tried to have this conversation on a number of times with previously. For whatever reason, it got lost. So finally, I contacted Misha Setner, who's the shoreline permit analyst, and asked him about it. In a letter that I sent to Andy Allen in 2023, which I've including in his exhibit, Setner says there's no such thing as a setback. None at all. So this information keeps gaining new life and it has absolutely no factual basis. So the in any case, the issue here is the deletion of the 75-foot setback and the PUDs. And we come to the finding, which is required, shall. This is not a negotiable issue with the statute if you're going to comply with statute. And the select board has a very positive commitment to following the statute. I'm asking you to do that tonight, even though for a lot of you, the Title 24 is new territory. The finding is that on the basis of what I said, is the report has no finding. It doesn't say that deletion of these two issues furthers the goals and policies of the municipal plan, because I've just read to you excerpts and summary of what the plan calls for, and they call for exactly the opposite. So, in conclusion, the North Hero plan explicitly calls for open lands and PUDs. Open lands are essential to the character of North Hero, and PUDs further the goals of the town and of the state. So I've now proposed at the end of the document I provided you with to make all the difference. Making whole just means you complete the process. This is not a complicated process. It just says you shall make a finding. And while I appreciate reinstating the 75, I'm advocating that you reinstate the 75 and the PUDs by issuing a finding that reinserting them brings the town plan and our ability to have land use development regulations into compliance with statute. I've made some specific recommendations, but I'm going to just summarize quickly what they are. That we are complying with the statute 441C. That means it shall be and amending the report that it does now comply with this, is now consistent with law. That the law calls, the town plan calls for these two things, these two provisions, and to bring the North Hero Municipal Development Plan into consistency and compliance, and to make full the VSA 24 VSA 441C, the 75-foot setback and the PUDs should be reinstated. If you do that, you're in compliance with 441, and the report is complete, and you can continue with 442. That's my testimony. Thank you.
Thank you, Chip.
Thank you.
Any other comment, David?
I guess so. I guess I'm just going to speak in favor of setbacks. I'm worried that 75 might not even be enough. I'm concerned that if it's set, if it starts at 95.5, the rate level, and a shallow slope like I have, the first 40 feet is just to get up to what's underwater in the spring. So you're really setting like 30 feet from spring lake level. And I know it's probably too late for this, but if it were up to me, elevation would be part of it. And I know the current state limit is 102 something, but the floods in 2011 were 103.5. To me, I would go to 104, 105, my property is eroding up in the years that my parents have had it. I've watched an enormous amount go into the lake. And so it just seems really short-sighted to be so close to the lake. I guess there are separate provisions for septic and all that, so if they build too low. But I'm just seeing a lot of houses being built way too close to the lake, and often it's because of, they're exempted for one reason or another. I've mentioned it before, but I was horrified that the North Hero House condos were approved. Cause that's pretty much on the lake. So I would just like to see some really ironclad setbacks, and more the merrier, bigger the better. That's my view.
Okay, thank you, Jeff.
I also wanted to talk about signs a little bit. I had a question about. It looked to me like in one of the earlier drafts, there was limited to 2 signs and that was crossed out. Was there a reason that we didn't want to limit the number of signs?
There, to limit the number of signs, and I know that we had discussed this. I guess it has to do with the majority of this, it comes along the lines of the political signs. Okay. It's very difficult to limit the number when you have, let's say, 5 open positions. 5 different people were running for different positions, okay? Not for the same position, but for different, that leads to saying, well, is that infringing upon somebody's political right to express themselves? If somebody would like to put 100 signs out in front of their yard there, well, we're looking at timetables here also, as far as to say, okay, we follow state law. And correct me if it's wrong, it's 2 weeks prior. 2 weeks prior to the election, and they have to be removed the next day.
That's for state right of ways.
That's in the state right away.
Local control. I just don't want to see a repeat. For one thing, when especially a large landowner has 1 million signs, it just starts a battle, and I feel like it's polarizing the community, because if they're gonna do a lot of signs, and our side's gonna do a lot of signs, and I just don't think we need this. And a bigger issue for me was the sign across the street, because it looked like it was a city hall sign. Most people don't know that that's private property over there. But one, it was too large, it was too close to the road. It was pretending to be an official city sign. And I would just love to find a way to not allow that to happen again. And to me, the 15 square feet is, that sign was maybe a little bit bigger than that, but not much. I mean, 15.
That was a 4x8 sheet. That was a 4x8 sheet. That was 32 square feet.
Okay, but a 3x5 over there wouldn't make me happy.
Right. Well, I'll put you to ease a little bit there. There won't be any signs across there.
Okay.
So, I mean, I was told by the landowner.
Okay.
Okay.
I was wondering if he knew what that was happening.
He was made aware of it and he was not too pleased.
I don't know when that might be the case.
Okay.
Well, but then there were the million signs where, somebody called him on it, and so he just put them all on a hay wagon.
Mhm.
I don't know, I just wish there was a solution to this.
I think that the difficulty is that government regulation of political speech is something that's highly sensitive, and for the municipality to contemplate it is time, place, and manner restrictions, not content. And if we want to take up time, place, and manner restrictions that still allow people to engage in protected political speech, we can certainly take it on, but it's fairly bite of the apple. Because the other side of that is enforcement.
Right.
And the enforcement of regulations, even if they are validly created time, place, and manner restrictions, I think has a potential to further divide the community. If there is, as you describe it already, some polarization occurring. Adding a regulatory entity in the middle of it, and promulgating new regulations might not result with the desired effect, but I think it's something that the board is willing to consider thoughtfully and deliberately.
I would just argue, this state, we don't allow billboards, so I mean, it's just odd to have an exception, you know, just for elections. I also wanted to ask, so I think it said the 15 square feet cumulative. So about a yard sign is a little over a square foot, I guess, I don't know. So does that mean I can have like 12 of them? Or does that?
Well, I want to be very clear that political speech is constitutionally protected.
The limit, it's like if I wanted a neon flashing sign that was 3 by 5, is that okay?
You'd have to file an application with the DRB if you wanted to put a powered sign, I think, but
So-
we're not the first line of review for that kind of
You
project.
would turn me down, you know why, so there are limits.
There are always some limits. Yeah, that's true.
Anything else?
I have, if you
I
gentlemen,
guess that's fine.
I agree with almost everything Chip said. Well, it's very important that we conform with the town plan, and just for your interest, Chip, we've applied for a municipal planning grant to start updating the town plan. We certainly appreciate your input as we go through the process. But as far as what we've gone through to get to this point, statutes, Title 24, 44, 41 is what the planning commission has to do. And that was our Bible as we went through the process. 44, 42, which I happen to have that's what the select board, what your responsibilities are. So I've got my copy with a bunch of highlights on it. I feel like we've complied with both statutes. As far as the report goes, the beginning of the report lists the purpose that was drafted for us by the Regional Planning Commission the last time around. Just cut and pasted it on this one. We've sent all of our proposed changes to the Regional Planning Commission. They had a couple of suggestions that we addressed. I think we've done everything by the book. I think the select board has made the right decision on the setbacks. And Chip, I'm not sure what you're getting at on the PUDs. I don't believe that when we updated the regulations in 2023, that we made any changes to PUDs.
You didn't.
Okay,
I fully accept some responsibility for that error in 2010. But it needs to be corrected tonight.
no, I don't agree with that. We've had the discussion about allowing PUDs in the shoreline district. We did not, in the interest of protecting the lake, not having concentrated development, we didn't think it was a good idea to allow PUDs in the shoreline district. However, in our updates, we have one exception. If a lot is kind of straddles the two districts and
25%.
75% is in the rural district, then a PUD could be allowed.
Mhm.
That's how we addressed it. Like I said, I was never aware that PUDs were intended to be allowed in the shorelands district. That was not in our previous regulations. We didn't address it, and we haven't addressed it here.
So in order to, you feel there that the planning commission has done the right thing.
Mhm.
Chip, you're saying there that they haven't.
If I'm not mistaken, Chip, you don't want the PUDs in the shoreline, correct? That was what you just discussed.
Well. Can I address the board?
Yeah.
Town plan is very specific. It not only says that you need to create opportunities for affordable housing, which is what is done through PUDs. But it says you are not allowed to engage in discriminatory land development. It also, and I'm now gonna quote, if the town plan says use land unit development to incentivize affordable housing and to allow for concentrated development in conjunction with conserved open spaces. At no point does it say, but not in our backyard or front yard or on our lakefront. If it, if you're gonna discriminate, you need to be able to not only conform with the town plan, but the statute. And my failure to catch this resulted in our bylaws being out of compliance with statute. And I'm asking that you follow the town plan,
May I ask a quick question?
yes,
Chip,
and put them back in.
Yeah, when you were reading earlier, the language that you quoted from the town plan, I seem to recall there being a sentence that said something to the effect of development in the shoreland district should not be concentrated, that those open spaces and the vistas should be protected. It seems that the town plan is asking us to be a little bit more nuanced, where PUDs may be a very important way to support housing that is more affordable, but perhaps more sparse development in our lakefront district to protect the natural resources is something that we should also keep in mind. And I think if that is the case, that our town plan wants us to accomplish both of those goals, that we might conclude that trying to focus PUDs away from the shoreline district is not discriminatory, but perhaps maybe what it's trying to do is to achieve two goals at once, to provide for affordable housing to be constructed while at the same time protecting and preserving resources in sensitive areas close to the lake.
Well, rather than to argue any one of those points, let me back up and say that I don't think anybody in this room has ever approved of PUD or has any experience with it, except maybe Corinne, I'm not sure. But I've done at least 6 or 7 of them. So if we could, although I don't have it here, but I can more or less tell you what a PUD is. It basically says, first of all, it's 4 acres. It's not just anybody. The land has to be 4 acres. It gives a density bonus for things that further town goals like open spaces or concentrated development. And it's not even sure that it's 25%. If you have 4 as one other housing unit, but the thing is that if you have a piece of land, if you have a piece of land and you line up your buildings this way, it creates a much different situation if you line them up this way. Not only that, but you can, we can encourage some combined spaces and further, every time you get a chance to, improve the development in terms of the town goal, the developer then reaps a benefit. Now, the other thing is that, one of the other element of this is, building windows, because when you have, this is just PUDs now. When you have 4 acres, you can subdivide it 2 ways, and you could very easily put 2 16,000 square foot houses on, just about. I don't have to look very far to see one that goes 25 feet to 25 feet, and is a solid wall across. Houses have gotten huge. So if you limit the building window on a 4 or 5 lot development on a 4 acre parcel, then you can say, okay, well, this is if you keep this as open space and you do several other things, and you limit the amount of space that you're gonna develop it as building sites, then you've accomplished a great deal, and you've preserved open space. So, you know, you can't, we have a mindset about affordable housing. But in terms of North Hero, affordable housing is often the addition of a smaller house that then is affordable for somebody to be a member of this community, a member of this recreational community, because a lot of we're not a residential community in an urban setting. We're an exurban setting, and affordability is the ability to come to North Hero and live. And it doesn't have to be so they can commute in Burlington, but it could be just to have access to the lake shore. And so all of that furthers the town plan. And by eliminating it from the, we eliminate all sorts of, we eliminate an important tool that the VRB and the plan and the town and to implement the town plan. That said, the discrimination comes that when you create a class of create a class where you're excluding certain kinds of development, and the state statute does not allow you to do that. It says you can't discriminate one kind of development from another. And you can regulate it, but you can't discriminate against it. In a sense, this is a moot point, but because most of the town's development on Lakeshore is on less than 4 acres. It's often on 1 lot. And the 2 things have happened. One of them was a state unintended consequence of accessory dwellings. Because now a 2 acre lot, which had been previously zoned for 1 dwelling, now have 2 potential dwellings. And the other factor that's adversely affecting our shoreline the lake, the lake, lakeshore district, is that houses of, somebody will come in, probably in my house. If you wanna drop dead and somebody sells it, there's a good chance they're gonna just raise it. And they're gonna put in a wall-to-wall building. And, you know, I've seen this with my neighbor, I've seen it with a dozen houses, and you don't have to go very far to see it, just driving down Route 2. So, but if you have, so this occurred to me that, when a recent application came to the board, I realized two things, because it was for a PUD. That we couldn't grant it because it wasn't, it was in the shoreline district, and that because we couldn't do the PUD, they were then free to build anything they wanted to, basically. And, if the one house was too small, they just use that, they just tear down the small house and build a huge house, and then their accessory dwelling complies with the 30%. Well, and if they, I mean, this could. So. We really need to be able to try to limit. Use the PUD in the shoreline district to limit the sizes of the areas of development. We're back to this question. You know, if you can't ask the developer to move it like this and incentivize it with, which is a provision of the PUD 25%. If you take that away, you're working against the town goals.
I understand your position, Chip.
All right.
And I would
Anything?
like to just one more thing. The finding that is required as part of 4441C, there is no finding with regard to these two issues, especially the PUD, because we just didn't, there, in 2010, there wasn't a me sitting here hectoring the other me to get my act together and follow the statute. So now you get to be me and I get to be me.
Yeah, I'm not so sure on this, on the.
A lot of the
PUD thing, but
A lot of the problem, Chip, is that PUD can go both ways too. Affordable housing, by definition in the state of Vermont, is 30% of your household income. So if I make $300,000 a year, my affordable housing is 30% of my household income. So a developer can come in and build a huge PUD and could be $400,000 houses for each person, still affordable housing for somebody. And that's by the state definition. So the only other way to do it is to just basically rewrite our bylaws from the beginning to make sure that that type of development doesn't happen and we allow something else, but you can't have it both ways. If you're gonna have PUDs on the shoreline, you have to be able to take into account that a multimillionaire may come in here and develop a huge PUD like they do down in Orlando and some of the other places in Florida.
Well,
I'm not so sure about how that fits in with the town plan as far as maintaining the look, the open space, this, that, and whatever. I mean, as far as keeping the PUDs limited. I think there, I mean, as far as I'm concerned here, the planning commission has. I mean, they have more to tackle. But when it comes to the PUDs there, I don't think people are looking to develop the lakefront so that it looks like Atlantic City or whatever.
I think you're wrong.
So you would be in favor of making it look like Atlantic City?
No, I think that a really aggressive developer would not only come in and do what he wanted anyway, but would easily challenge. Ask for 5, and if you didn't give it, he'd take it to the Supreme Court and. I don't know, it just doesn't,
So you're saying there implement the PUD there in the Shorelands District. However, add numerous restrictions,
say that last part,
add restrictions.
well. Your restrictions would have to be. On any PUD. So
That's what I'm saying, though.
Right.
But I mean, whether
Gotta
it
be
be
fair for everyone.
shorelands or whatever, but that the PUDs there would have numerous restrictions.
well, they
So
do,
that you maintain,
they have numerous restrictions, I mean, I could go down the list of what they are, but. The fact is that, you can't have restrictions on some. PUDs and no restrictions.
then I understand that.
And just to answer your question, already plenty of restrictions on any development in the shoreline. Including. Adverse development, but part of the PUD is that they have to comply with the town plan. So we're back to,
Wow, that's kind of where I'm going. It's coming around full circle again. I guess when it comes to the DRB then. That makes it very difficult to render a decision.
I wouldn't think at all.
Well. If you have. By adding the PUDs. To this. To the shorelands. You think that makes it easier?
Yes, and I would say that, that not only does it make it easier, but it also makes it a lot cleaner. Because then you get to implement town goals. And, in the 6 or 7 PUDs that I've had, I rendered a decision on throughout the years. They all came out extremely well. I mean, it was a really positive experience for everybody. Because everybody knew the rules, they knew how. Yeah. Very few people took advantage of the 25% bonus. But, the resulting development pattern. Was the town plans. Advocating the development pattern that is consistent with certain goals and existing ones. Was furthered by the PUD. And thus made the DRB's role in it a much easier advocacy for the town plan and the town goals. And it created a very positive kind of development.
Okay, well, so what I'm understanding, or what I'm getting. Is that. There's potentially here conflict. between the town plan or the interpretation of the town plan and the versus the bylaws they're concerning.
I come back to the consistency doctor. The town plan, the state statute, the town bylaws have got to comply with the town plan. The town plan has to comply with statute. And not the other way around.
Okay. All right, thank you, Chip. Any other further discussion?
Just to back up, recap, an interesting discussion on PUDs. It's not something that planning commission had even attempted to consider. Not part of what we're proposing here. Definitely something we can look into. But just to back up, we passed, you folks approved a comprehensive update to our development regulations in December 2023. We in the planning commission, members of the DRB, zoning administrator, shoreline committee, said, yeah, let's give them a while to take effect, see if we need to do some tweaking. And that's kind of where we are. All we're trying to do is tweak what was passed previously. I feel like we conform to all the state statutes. We've done everything by the book, and I stand behind what we did. I would recommend that you approve the changes with the possible exception of signs. I know you may or may not want to have further discussion on that. But again, I stand behind what the planning commission did.
Okay. Anything from any of the other board members?
Oh,
What is the pleasure?
so. As a public hearing. The outcome of this meeting is to take a final vote on,
It's up to you folks. You're required to have at least one public hearing. You can have more.
I mean, I think at this point, perhaps what we do is consider adjourning, take into account what we've heard for testimony today. Mr. Porter's indicated that he has additional exhibits he intends to send to us. I'd kind of want to at least have an opportunity to review all that before a final decision is made and move forward.
I like that idea.
I'll make a motion in that case to adjourn the public hearing.
Do I have a second? Claire seconds. Any further discussion? All those in favor say aye.
Aye.
Aye. All right, the meeting is adjourned at 7:58 PM.
Thank you all.
Thank you all for coming out. And Chip, you will send that stuff along? Chip? You'll send that along? Thank you.